Good morning, everybody, and welcome. I am Riccardo Masucci, Director of Privacy Policy at Intel, and I have the privilege today to co-moderate two parallel panels, one in Brussels and one in India. I think we will be able soon to see our friends in video conference from Delhi. When we decided to organize this panel, we truly want to celebrate the Data Protection Day, Data Privacy Day in a truly international way. And so this is the idea of having two parallel sessions, one in Brussels and one in Delhi. Let me first thank our technical teams who made this possible. Maybe. I still see my face, which might not be the best view of the day. Oh, but I see David and his guests, so good afternoon to New Delhi. And let me start then saying that in Delhi we have David Hoffman, Global Privacy Officer and Associate General Counsel at Intel. David will help us interacting with Rama Vedashree, CEO of the Data Security Council of India, and also with Rahul Sharma, who's the founder of the Perspective Consulting. Here in Brussels, as you can see, I'm surrounded by renowned privacy experts. I would say privacy superstars, starting from Professor Cannataci, UN Special Rapporteur on the right to privacy. My left, Bruno Gencarelli, Head of Unit of the International Data Flows and Protection Unit at DG Justice at the European Commission. Malavika Jayaram, Executive Director of the Digital Asia Hub, and Michael Donohue, Senior Policy Analyst at the OECD. Before giving the floor to Joe Cannataci for setting the scene and introduce this session, I would like to remind to our speakers and the audience that David and I will ask one question per speaker, and we will have a follow-up question. This will give us more or less 20 minutes at the end of the session for Q&A. So let's jump in there, and Joe, you have around 7 minutes for the introduction. Thanks a lot.
Yes, thank you very much, Riccardo, and thank you very much for your invitation to be here. It's really very appropriate that we are both celebrating the Puttaswamy judgment, but also reflecting upon it and its implications, both for Indian society and globally. And you have asked me to take very much the global approach. And to a certain extent, ladies and gentlemen, what I will be doing, what I'll be telling you, is what I've said to the Indian government in my response to its consultation on the white paper on data protection. First of all, the point that I have made is that while it's important to go for data protection regulation, it's also very important not to take a minimalist approach, right? Which is one that we've seen in some countries, regrettably also in some European countries, but which has been changing dramatically also thanks to the introduction of the GDPR in Europe. By talking about a minimalist approach and instead going towards a position where India can take a leading position in privacy and data protection. So that's the first point that I would see here. As India follows up its work in the wake of the judgment, therefore, this is an opportunity for India, as the world's largest democracy, to show its ability also to take a lead globally. And let me give you one or two examples. Firstly, of course, we're going to hear other speakers probably talk about the advantages for Indian industry to align itself with the GDPR and so on and so forth. That may be coming later on from other speakers. However, there's much more to privacy compliance than that. And apart from starting off with India's 1.3 billion citizens and what it means to them, we should also point out that there are various dimensions of privacy which may not be coming forward. If you look carefully at the Puttaswamy judgment, you will find also references to personality and the development of personality, which is something that cheered me greatly, because within the United Nations in March of last year, we had a strong resolution which, amongst any other things, linked the right to free development of personality to the right of privacy, freedom of expression, and other rights. But secondly, and just as important, is the way that Indian law should align itself not only insofar as, shall we call, civilian approaches to data protection, but also to surveillance and surveillance carried out by the state, both internal surveillance and external surveillance, foreign intelligence surveillance. This is something which India sorely lacks at this moment in time, I think. It is once again an opportunity for it to take the lead internationally. Let me just mention that last week, in a co-event, co-organized by my mandate with the EU-supported mapping project in Rome, we examined a text which is now public on my website with the provisions for securing protection of people's rights internationally in the realm of surveillance and privacy. And amongst other things, what this calls for is basic protection, such as the creation of an independent, a truly independent oversight body for the oversight of intelligence and surveillance. This should couple with the establishment, I would hope, of an independent body for what we would call more conventional privacy and data protection functions. This is something which is gradually sweeping across the world. It's an emerging development, and it's something which we think is very important. We are having ramifications about this here in Europe where I sit, but also worldwide. Wherever I go wearing my UN hat, whether it's Asia, South America, America, all other continents, I find serious interest, including in Africa and other places, in the impact of surveillance, both domestically and internationally. So I would point out that this opportunity for the Indian government will not come along every day. The ability to focus on privacy in a holistic manner, looking at the way that privacy regulation in India will affect companies, the government, police forces, intelligence services, and above all citizens. The citizens who are at the end of all this, the citizens who are having to cope with increasing intrusion in their day-to-day lives, especially as Indian citizens and citizens worldwide move further onto the internet and are in a position of being surveilled through the increased use of technologies like their smartphones and access to the internet. Let me stop here for now, Riccardo, hopefully to be within the time. Since I am normally also chair, if people see me looking at my smartphone, it is not because I am being impolite, but it's because it's serving as my watch throughout the session. So I'll ask, therefore, the next speaker, who I think should be... do you want to come in quickly, Riccardo?
Yeah, I would like just to thank you for this great introduction. I couldn't have asked for a better one. And really, we see here an opportunity not only at national level for India to shape its regulatory environment in a way that can really foster innovation, but also protect individuals. We have learned in the past that privacy protection doesn't stop at the border. And so we learned some lessons with the GDPR, with Safe Harbor, Privacy Shield, that really protection of citizens goes beyond the single jurisdictions. And so this is why we see the importance of a convergence of privacy approaches around the world. At Intel, we have called for years policymakers and industry to rethink privacy in a way that we can look at the fair information privacy principles to be applied in a way that is that allows both innovation and protection of individuals. And my former colleague Paula Bruning was used to call the fair information privacy principles the global language for privacy, and the fact that they have been around for the past 40 years proves the fact that they were very effective. And since we have, the lack of having on the panel somebody who led the revisions of the OECD guidelines, I would really like to hear from Michael, based on his experience, which are the elements and the aspects that could make really this reform in India successful. Floor is yours.
Thank you, Riccardo. And good afternoon, everyone. Good morning, everyone. Good afternoon in India. So as Riccardo noted, some 40 years ago, a dedicated group of national experts gathered at the OECD and developed the first international set of privacy principles. I like to imagine that there were some visionary international bureaucrats there as well, helping them along, but they really have stood the test of time in many important ways. And even today, the basic principles from those guidelines remain an inspiration, and I believe can serve an important building block as India, or indeed any other country, designs a privacy regime. Now, of course, neither time nor technology have stood still in those 40 years, and in 2013 we did update the guidelines in a few ways, which I might mention this morning. So let me start with what we call national privacy strategies. And while, as we've seen in India, courts and constitutions can play an important role in kicking off the discussion, when policymakers turn to their toolkit, legislation is the primary tool that they reach for. There is, however, an increasing recognition that, although essential, legal protections are only one element in an effective privacy framework. Today's privacy frameworks need to be tailored to an increasingly data-driven economy and society in which we operate. So we think privacy protection measures should be developed through a multifaceted strategy that reflects stakeholder input and is supported at the highest levels of government. That's a key point. So we have work underway now at the OECD to try to articulate what national privacy strategies should include. One starting place is what the privacy guidelines call complementary measures. These are complementary to legislation. These include education and awareness, skills development, professional training, and technical tools. Privacy strategies should also require coordination within governments. And let me give you one example. Last year, the OECD Consumer Committee did a study of 10,000 consumers on the drivers of trust in what we call peer platform markets like Airbnb and Uber and eBay. And keep in mind, so these are transactions, commercial transactions between individuals, non-professionals who don't know one another and who may never encounter each other again. So we expected that the challenges the concerns they would have would relate to dispute resolution, misrepresentation, et cetera. What we found out is that the top two drivers for trust in these markets are payment security and personal data security and confidentiality. So why do I tell you this? I think one key takeaway is that consumer protection agencies need to work with data protection colleagues to do their job effectively, and vice versa, I would say. And I might add that competition and communication regulators should also be involved. The regulatory silos need to go, and a strategic approach can help make that happen. So my second point concerns risk-based privacy management programs. The revised guidelines have a sort of practical emphasis. In a new section on implementing accountability, we introduced the concept of privacy management programs. This is the key operational vehicle for data controllers. These programs should reflect a risk-based approach through which risks are assessed, identified, mitigated, including through incident response planning. So there's more to that I could say, but let me just conclude with one final point on improving the evidence base I think today the role and the scale of data use means that privacy rules have to be operational across a huge range of commercial and social activity. So getting the policy right really matters, and we need better evidence to do so. So the OECD is currently working with the International Commissioners Conference to improve the international comparability of the information gathered through data breach notification requirements, so we can better understand some of the trends out there. Likewise, our policies need to reflect the way the humans they target actually behave. We need to take behavioral insights and research seriously. Going back to that study I mentioned, only 17% of consumers reported reading carefully the privacy policies before clicking their agreement. So there are behavioral limitations on what can be accomplished through consent, and I think we need more research on how to do that.
Thanks a lot, Michael. And I would like you to probably give us some insights also on another important effort led by the OECD, so the transborder data flows activities. So if you can say something around that, it would be very grateful.
Sure. In fact, from the start, the OECD's interest in privacy was not limited to establishing good practices for effective protection of individuals and their privacy. We also wanted to develop common international approaches to that protection, and this would minimize the need to restrict data flows and the economic and social benefits that they bring in the name of privacy. So we've always had transborder data flow governance in the privacy guidelines. We updated it in 2013 more to simplify and modernize it than a radical revolution. So let me describe it briefly. The first provision states what's really already implicit in the accountability principle, the starting place when thinking about how to protect data in the context of global flows is the data controller. The controller's responsibilities do not stop at the border. This reflects, for example, the approach in Canada under the PIPEDA legislation there. The second provision retains the general notion from the 1980 guidelines that countries should not restrict transborder flows to other countries that implement the guidelines. That's the basic approach. To this, though, we've added the notion that enforceable safeguards put in place by the data controller should also prevent restrictions on the free flow. This is new to the guidelines, though it's commonplace in many national laws, contractual clauses, BCRs in Europe, for example. And finally, there's a third provision that recalls that any restrictions on data flows should be proportionate to the risks presented. It also enumerates the considerations that should be brought to bear in making that evaluation. The guidelines are minimum standards with respect to, and that includes the transporter data flow section. So for our European members, this accommodates the reality that the relevant standard in Europe is adequacy. And all of this is wrapped in a broader policy objective of improving interoperability of privacy regimes. And I think as India moves ahead to develop its own regime, I hope it can help get us closer to that somewhat elusive goal. Thank you.
Thanks a lot, Michael. And then, David, here we added a lot of elements to this discussion. Many interesting points were made by both Joe and Michael, interoperability, restrictions to data flows, but also there were some suggestions regarding a broader look at also surveillance, internal surveillance, external surveillance. So there's a lot here. Before going the floor to the others, giving the floor to the other speakers, I would be very curious to hear some input from Delhi. So the floor is yours, David. We cannot hear you.
Can you hear me now?
Yes, loud and clear.
Great. Excellent. Thanks a lot. It's wonderful to be able to do this. Riccardo had mentioned that this is in celebration of Data Privacy Day and the signing of the Convention 108. It's actually the 10th anniversary of Data Privacy Day. Data Protection Day existed before that in Europe, but a little over 10 years ago, a European Commission official at the time, Leonardo Severa de Vos, who is now the European Data Protection Supervisor's Office, was visiting the United States on an academic relations between the United States and Europe if we held something called Data Privacy Day every year in January and focused on transatlantic cooperation and understanding. We started with an event that first year at Duke University, where we were lucky to have many of the absolute legends of data protection and privacy, including Supervisor Riccardo, who arrived and helped. And from that one event, we now have hundreds of events happening all over the world. I can't think of a better way to celebrate the 10th anniversary of fostering better cooperation than this video link between Europe and India. India as a country showing, as Professor Cannataci noted, tremendous opportunity and a proficiency and a strategic objective of using data to both improve the economy and improve society. And going through an analysis now of how to do that while also respecting privacy. This is one of the critical goals that we also have at Intel, and I am honored to be able to help bring this conversation together. So to keep it moving, then, Raul, I wanted to start with you, and maybe you can talk a little bit about how important are international data flows to you?
Right. Thank you, David, and thank you, everyone. I think whether or not data flow be promoted, there are no two ways of it. Everyone knows the benefits of data flow and the benefits of globalization was a very good thing. The benefits that they have brought to a country like India, I think it's enormous. So the conversation is not whether we should promote data flows or not. It should be promoted. The discussions have to happen around how it should be tackled so that it brings the benefit of promises, but also ensures this very regulated, adequate price protection is built throughout. Right? And we have to, as a country, look where we stand currently. What is the landscape that we're looking at? We don't have to just focus on now, we have to look 10, 15 years down the line. What we're trying to build. What is the framework that we're trying to propose that will help or enable cross-border data flows, fuel the economic growth, realize democracy, data passion, and all those things. So these are all very important considerations when designing framework. So I would like to take off the point with Professor Cannataci has made. India is at a very right stage to formulate a law which meets the requirement of what Indians want and meets also satisfies the requirement of what the global community is looking forward to when it comes to regulating data flows and having interoperable framework between the data. And yesterday, Prime Minister Modi asked the World Economic Forum, he mentioned this point that the impact of globalization and the value it presents is a very huge opportunity. And that's all like we all believe. So if you look at the overall outsourcing percentages and how it is like globally, majority of the business outsourcing companies, they rely on a lot of data flows. The IT industry, I think Rama goes to the lab with it. That is fueling the economy. And if you look at the just mere percentage of what percentage of GDP does internet contribute to? Not we just focus on internet, not data flows, which are beyond internet also. It's a huge percentage. It's going to only increase. So we have to sort of, try to formulate something which is reflective of what we need. And India is definitely in a position to take a lead because we have leapfrogged certain generations and with globalization, everyone is at a common state. So we have to sort of take a position that we didn't get for neutrality, not something. The way it started in the US, but the way it's, it's changing the momentum in India. Everyone got involved with their opinions, the rules were framed itself. Similarly, I think we have an opportunity to create something which is useful in the context of the development for India, supports the globalization, and like not just imitate what the European law is.
Now a bit better. I was looking at our friends here in the room to make the volume a little bit louder. Thanks.
Okay, we'll just proceed. I was mentioning Prime Minister Modi's remarks against protectionism come at a time we're still hearing desires for data localization. How do we relate these two concepts to each other?
So I think there has to be sort of a way on how we look at the subject when it comes to regulating of cross-border development. Now, the EU approach of handling this matter has been very bureaucratic in a sense, and I like speak in my personal capacity, not as country leader for IAPP, because the only suggestion I have to make is not speak on policy matters. Yeah, so like we have seen that there have been increasing tendencies. So, like the way Europe started using data protection as a lever to sort of regulate data flows, in turn it created an economy wherein people who wanted to leverage the benefits of outsourcing could not, because it became a non-starter. It became a barrier, and we have had the opportunities to interact with a lot of businesses in Europe who want to leverage the benefits of outsourcing, but it has come to a level where the businesses do not want to get engaged with the regulators, obtain their permissions, and get all the necessary approvals for all of this. So when you formulate laws that become non-starter for businesses, then it sort of becomes very detrimental for the economy. Same is the case with data localization also. The Europeans, they formulated laws, they tried to divide the space between Europe and outside Europe and had different sort of policies for all. And when you sort of formulate such a law, we also saw that this combined with the mass surveillance which became public, there is an increasing cry out for localizing data so that the local governments can have a better control. That's a misnomer, but still, like there is an increasing tendency of the governments to localize data. And like we have to also see and reflect whether the rules and the regulations that we create, do they breed sort of protectionist mindset? Do they give others an opportunity to create laws or to sort of talk about laws which say that, Europe has a law which talks about data. This does not necessarily talk about data localization, but it definitely asks for having better controls and within the data can flow easily outside we need to have more stringent controls in place. And that we are seeing is transparent to becoming more and more aggressive and stringent by some nation states, and some are saying that data localization is the way forward if they want to protect privacy. So whenever the countries and regions like Europe are formulating laws, they normally have to consider what is important for them because they are seen as a leader in the space of regulating data protection. They also have to formulate laws which do not breach the tendency and the mindset for protectionism, which gives a lever to other countries to enact similar laws.
Thank you very much, Rahul. And I think to further that conversation, particularly as we're all going through an analysis globally coming out of the existing 9546 directive in Europe and now moving to the general data protection regulation that's coming into force
entire privacy and data protection principles and best practices, particularly as IT industry started scaling up last 10 to 12 years back, serving global customers in currently about 80 plus countries. I think we've come a long way in terms of driving global best practices, and we are very happy to participate in this conference. And I would also like to reassure the point that the professor raised, Professor Masucci, about India being in a position to be able to take a holistic approach towards data protection and privacy, because as we are drafting, potentially drafting the legislation in the first quarter or the first half of 2018, I think we are in a situation where we can understand from all the global best practices, the global regimes that have come out, some of the updates that have happened in the countries, and we are at least going down that path. In terms of the Data Protection Committee, currently the draft white paper has been published, and we are in the process of doing public consultations. We've completed the consultations in 4 cities. Yesterday it was in Mumbai. A point that I would like to highlight is this is the first time where a very senior chair of a committee has actually gone around to various cities and conducted these public consultations in a completely open listening mode, almost from morning 10:30 to evening 4:30. Bangalore and Mumbai, I know it went on even beyond 4:30. So we are in that public consultation mode, and we are receiving the inputs already. I'm told 100 submissions have come in. There is a law research firm within legal who is supporting the committee in doing the analysis of all the submissions. And post that, we've had about 3 meetings of the committee so far, and we believe that once the summary of the submissions and the 4 public consultations that have happened, which the legal team and the core team in Ministry of IT is doing, will again deliberate on that. So some of the insights I can give, I'm not really speaking for the committee, but some insights that I could share on what I believe is happening now. Very clearly, we believe that we will make a white paper which will be submitted to the government, and we are not currently drafting the law. At least that's what we understand from the chair or from the chair's inputs to the committee. So we will be finalizing a final white paper or a final report actually from the committee to the government based on all the deliberations. And I would like to believe, from what I understand from the chair as of now, that that final white paper will also be put up to the public domain before it is submitted to the government. So probably there will be an opportunity for everybody to look at what the government is currently, I'm going to understand. We are looking at coming up with recommendations for a horizontal framework for data protection, which will work across. And then there might be sectoral level regulations, because how do you go ahead and implement and enforce privacy and data protection principles in the digital payments industry or the financial services industry is extremely different from what it would be in the healthcare industry. So I think what our committee is looking at is it's not really looking at a vertical-based approach, but a horizontal framework of, at a country level, what should be the implementation framework. And another point that I would like to reassure, particularly the global audiences, is India believes that we are capable of making the digital economy a $1 trillion economy in the next 4 to 5 years. And we believe that the data economy piece will be one of the largest chunks of this overall digital economy. And given the proliferation of the mobile first strategy, the mobile internet users, I think data will be a big piece, and the innovation on top of that data will happen. And because of which we believe, I would like to believe, because I still don't know what the final submission from the committee will be. I can't speak for the whole committee. I would like to believe that it will be a very progressive recommendation report that will go from the government, because we understand that cross-border data flows and a very strong enforcement regime to ensure that privacy breaches are not treated lightly, and there is we scale up the awareness and capability of not only the large enterprises which deal with personal data, but also the government agencies which deal with a lot of personal data, and a lot of small and medium developers, small and medium enterprises, small mobile app developers which deal with personal data. How do we build up that capability? So we in the committee, we were saying that we need to look at how do you build this privacy awareness culture from the citizens' point of view, from small and medium application developers' point of view. So there would be those recommendations. Similarly, I think once the committee submits its final
particularly just real quickly as a follow-up question, one of the things when we've spoken, and I think this came out a bit in your remarks, it is a difficult task to optimize for two different values. One being to give trust and confidence enough to others that information is going to be handled appropriately, particularly with India being a resource that will, be managing the personal data of a lot of people from outside of India. And so giving trust and confidence to our friends in Europe that the information is going to be protected, while at the same time providing enough freedom for innovation to happen in the use of that data. So are there any thoughts real quickly that you have about what the paper might recommend on how to handle cross-border data flows and international data transfer?
It is a very tricky balance to be able to balance strong data protection and privacy principles with keeping the opportunity open for everybody to innovate on that data, build solutions across verticals, whether it's in payments and financial services. There is a lot of debate going on particularly the cross-border data protocols. There were a lot of recommendations that had come up to us to look at what the Cpdp principles are, any of the ones that have been being discussed and advocated. We would like to believe we on behalf of NASCOM and DSCI members, we are drafting the submission. We believe particularly if you look at India as a destination for data innovation and analytics, we are already close to 600 plus entities which are playing in the analytics space, and almost 500 of them are startups. That is, maybe 100 of them are global innovation centers, global in-house centers which are doing analytics for their parent corporations. So we believe that analytics and innovation needs to happen, but of course there has to be the protection where the data protection of not just foreign citizens, which is processed in India, but of Indian citizens also should be maintained. So the purpose for which data is collected so that the individual privacy intrusions won't happen when information is stored. It is a tricky balance. We need to understand what should be those technology solutions which will help to enable that, and what should be the framework and what should be the principles to which you promote better privacy practices, whether it is privacy by design kind of principles, privacy seed kind of principles. We are advocating all of that. And it is a tricky thing. We need to see how to come out. We do understand that cross-border data flows and enabling data flows from all geographies which India is currently servicing and also service regionally. That's the economic interest of the country.
Great. Thank you very much. Riccardo, I'd like to turn it back to you in Brussels.
Thanks a lot, David, and thanks a lot for all these useful insights from you and our distinguished speakers there in Delhi. This really gives the idea how lively is the debate at the moment, how dynamic is the situation. But I would like to ask a question to Malavika, who has an extensive experience in Asia, in India and Asia, both personally and professionally, I would say. And so the situation is very dynamic in the old region, and privacy has gained a lot of prominence in the past few years. So I would like really to understand from you, Malavika, in your view, which are the challenges and also which are the differences in approaches within the region and in comparison with, let's say, the Western privacy regimes.
Yeah, thank you, Riccardo. I think this room is a perfect visual metaphor for where we are. Very optimistic about the scope of interest, very realistic about how it actually matters to the rest of the world. So I just sort of to set the stage for, where this fits. No, we are here. We are competing with blockchain, so who could possibly win? But I just wanted to pick up, I think, on the last comment that Rama made about, how it's important for Indians as well, because I think, for me, one of the great things about this judgment is showing that privacy is a right that less wealthy countries can have and be entitled to. And it's not just about whether you're a democracy or not. I think it's also about socioeconomic status. So I think veering away from this whole privacy is a luxury, even in Western countries kind of argument. I think the fact that we set the stage that this is possible and it's something that's wanted and is deemed inevitable, inviolable, I think for me that's a very moving thing that this happened. I read the judgment again this morning. Of course, easy to read 547 pages before breakfast. I was skimming, but it really moved me that this was possible out of my country and my Supreme Court. The starting line to me was almost like one of the nicest novels ever, you know. 9 judges of this court assembled to determine whether privacy is a constitutionally protected value. I loved it, you know. So I think it's important to show that it's not just about the external value of developments in Asia, 2 countries doing trade and business. It's not about data flows alone, which is a nice externality to have and will also empower people within the country. But I think to show that this is something around dignity and personality, as Joe said, that it's something we can demand and feel entitled to and enact and enforce in different ways, I think that is the really huge thing with this judgment. And I think it's about focusing on Indians as citizens, stakeholders, and equal participants in this dialogue, not as data processors, not as subjects, not as targets of development, and not as call center operators, you know, trying to fake a really bad American accent in the middle of the night. So I just wanted to say that before I talk about the challenges and opportunities. I think in terms of challenges, the first one is that Asia is not a monolith. You can't think of, you know, there are different trajectories, there are different histories, there are different approaches, and I think looking at Asia as one sort of zone does it a disservice. There are countries that are very far advanced that have been dealing with it. You've got the Japans, Koreas, Hong Kong, Singapore. You've got countries very developed, and you've got countries, like 26 countries don't have data protection laws around the world. So I think framing that is useful. I think there is this sort of, and this is sort of the culturally relativist versus universal values kind of argument. I feel when it's suitable to say, oh, you know, Indians don't care about privacy or the Chinese don't care about privacy, that's used as an excuse in certain negotiating tables. But when it's useful to say that we have rights and therefore you can't have A or B happen, I think it's sort of one of those things that's a double-edged sword. People use it conveniently depending on which side they are. As a privacy lawyer, as someone who's interested in human rights, I really dislike any attempt to divide up the world based on culturally relativist norms. I think it is a universal set of values, and you know, whether enacted through the OECD, through fair information principles, whatever your source, and you know, wherever you generate your founding principles from, I think the fact that it is something essentially human and universal is something that I think keeps bumping against this idea of, and I think it's a really complex issue, right? I think the challenge is you don't want to impose Western values on other countries. You don't want to be paternalistic and neoliberal about all of you should have the same sets of norms that the EU has because it's the best. I mean, even America doesn't agree with that, so why would the rest of the world? So I think there is that sort of fear. But I think at the same time, if we say, oh, poor people don't deserve it or they don't understand it, or if you were to do a survey in Asia, people wouldn't care, therefore we need to reflect that will. I think this is one of those moments that sort of Anita Allen talks about in Unpopular Privacy, where she says, it doesn't matter if all of society agrees that they don't want something. We as a society, part of evolution and civilization is saying we deserve certain rights, and it doesn't matter if we're being paternalistic about pushing those rights down. This is one of those values that protects not just individuals, but societal norms. It enables other norms. It enables speech. People wouldn't speak if they didn't have privacy. So I think, you know, we have to see it as an enabler of other rights that people may care about, even if privacy isn't central to what people want. I think there is one of the huge challenges in the region is this sense of perceived apathy that people don't care, that it's not integral to their own culture. And I think you can see why that's the case, because if you look at some sort of Maslow's hierarchy of human rights, there's always something more important. People don't have food, you know, education, shelter. Privacy seems like a luxury. It seems so way down that chain. But I think it's not just about apathy. It's sort of like Joe Turow and others at UPenn have talked about. It's about helplessness in the face of, like, how do we enforce these rights? What power do we have when all of the platforms, the systems, the norms are geared against us so heavily? And I think essentially, as a lot of these things are, it's about power. When you have imbalances and you have information and power asymmetries, it's pointless to say that culturally people don't care. It's like, we care, but we don't know how we could possibly enact this. And that's how when people come to me and say, Indians, or even Indians tell me we don't care about privacy, and I don't talk about legal instruments. I turn around and say, do your parents know you're gay? Do they know that as a Muslim you really love Scotch whiskey from Japan? Or do they know that you're dating someone Muslim? If you tell me those things are things you don't feel you have a sense of secrecy or privacy around, you're lying. So this idea that there isn't something we're all private about, or that as a culture we don't care, I think that's one of the challenges that we're trying to work with. And also this idea that it's a luxury. I mean, even now with the debates around Aadhaar, the biometric identifier, there are voices that say, oh, the people speaking against it, it's sort of, it's kind of like the old champagne socialists in Britain. It's sort of, oh, it's a wine and cheese thing. It's a few elites making decisions for the country. And it's an orchestrated campaign against something beneficial. And as a friend said, it's an orchestrated campaign by people doing this for no money without any influence. Of course, it's an orchestrated campaign of civil society. So I think those are some of the sort of issues we're often challenged with in Asia. And I think, again, this idea of balancing rights, which, again, is something this judgment doesn't go into because it was not put to the court. So it's sort of a gray area around, yes, we have a fundamental right to privacy, but how it balances against national security, against surveillance, as Joe mentioned, against other kinds of interests, it's not really clear. And I think finally, in terms of challenges, with a lot of Asia, it's always about the enforcement. You can have the best law on the books, the most profound judgments, the most beautiful references to, very, very profound principles, but the actual reality on the ground is data is leaking, there's a gray market in identity, there are people buying and selling it on, a pin drive for like 500 rupees. There are leaks, there's hacking. So I think, and also in terms of enforcement, if your enforcement is toothless, or if it's a very small fine, years ago when the ID scheme was being debated, the fine for actually copying the entire database of the entire country's biometrics was such a nominal amount that someone was like, why would I, as a business, go and invest in understanding my base? I would just go and copy this database and I would pay the fine and get away with it, and I'm getting deduplicated, verified, authenticated data at a ridiculous price. I would violate the law in order to have it. So I think it's about incentives, but I think it's also carrot and stick. You also need the enforcement to really be vital and vibrant.
That's a really great insight, Malavika. And actually, on this last point, I think that the GDPR, one of the great if you want, elements of the GDPR is also making the enforcement of the rules, in a way much more important in the overall privacy framework. And so, since you know very well the Indian situation, I would be curious to hear your point of view on that side, on the enforcement side, if you want to develop more, as the overall discussion around values. And we understood from your previous from your intervention now that the privacy is intrinsically part of every society, Western, Eastern, everywhere in the world. So, but I would like to see how do you to understand how do you see the developments in the next few months. You mentioned also the database system for identity in India. So, and these aspects are extremely interesting to me, and I hope also to the audience.
I think, actually, I'd like to touch on the GDPR, but on a slightly different angle than the enforcement. Actually, it's about the sort of right to explanation. I think that's something that's really interesting with a lot of the black box schemes that we see, where the algorithm is inscrutable, it's not explainable. And I think that's something that's going to be really big in this space for Asian countries. But also, I think the shift away from personally identifiable data. I think recognizing that with things like artificial intelligence, machine learning, the Internet of Things, that it's not necessarily about you being the data subject and about data that identifies you individually. I think it's about you as a class. It's about you as a member of something bigger than you, where you can still be discriminated against because of being a member of a class, and sort of machine-based decision-making where it's you as a member of that class that can actually deny you certain rights and entitlements. It's not just about you personally. So I think that notion of privacy is shifting, taking it away a little from the individual and about the class and society. So I think watching how the GDPR influences the right to explanation and ways in which you look at PII is going to be really interesting in the region. I think also there's a huge sort of opportunity, because if you're dealing with people who are digitally illiterate in a lot of these countries, or even subject matter illiterate when it comes to technology, they're new adopters, they're not digital natives, you have issues of age, you have issues of marginalized populations. I think this is a great opportunity to actually force companies and governments to be explainable and scrutable, also to tackle the sort of literacy issue. I think it's a great opportunity to sort of further the privacy by design or privacy by default, because I think if you expect people to enact their own privacy, that's not going to happen. I mean, we find it hard enough, with the statistics Michael was sharing about, whether people read privacy policies, whether they parse and understand them. I think sort of the role of defaults and the role of design is going to become really huge. And I think that's something which is very aligned to the growth and innovation story, because I think in a lot of Asia, if you talk about privacy, they think, oh God, you're shutting down innovation, you're taking us backwards, you're preventing us being competitive. So I think the trade and competition angles, it's a great way for people to actually find ways to create products and to innovate around this, and to actually see privacy as a competitive advantage. As you see that people are being violated and data is being leaked, it's a great opportunity to come up with products and services that actually build trust. And I think privacy may not be the right frame for people who don't care about human rights, but trust is. And I think that's why even when we did an event at the ICDPPC in Hong Kong, we talked about AI and trust to show that it is an enabling thing. It's not something that's trying to shut down systems. So I think seeing privacy as a driver of innovation rather than something that kills it is a really useful frame. And I think to the extent that we're doing all kinds of social engineering and looking at behavioral economics and how people use technology and the different affordances that it has, I think it's a really rich space for countries to innovate in Asia, especially when we're not exactly lacking on software talent. So
it's a very good point, as your point on privacy as a driver, as a competitive advantage. We have said this as Intel for many years, and we really think in the privacy by design process, and we really understood how thinking, putting privacy within our design process, this will really improve our technologies, both from a privacy and security perspective. So you mentioned also the point on automated decision making, and we should probably organize a panel for next year on this specific point, because it's fascinating. For the sake of time, I would like to ask a question to Bruno. The European Commission in 2017 really stepped up on its strategy on international data flows, Bruno, and since then you started going every second week to Asia, I think, or even before. So we know that negotiations with South Korea and Japan are going well, but we would be delighted if you could give us an update on this, and how in relation to the panel today, how these negotiations could actually pave the way for India to be in the scope of an adequacy decision.
Thank you very much, and I'm very pleased and honored to be here and also connected to Delhi. I absolutely agree with everything you said. everybody said, but I think that what you said stressed exactly put the focus exactly on the right points. Yes, I can speak about Korea, South Korea, and Japan, but I think what is interesting in our work with South Korea and Japan, and what is interesting, and how then it can shed some light in on this conversation, is that that work is the reflection of a trend towards convergence, upward convergence, around a number of common principles, which are the recognition of privacy, data protection as a human right, fundamental right, which are the existence of overarching legislation rather than sectorial rules, which are a set of enforceable rights, which are the existence of an independent supervisory authority. And that's not because these countries all of a sudden fall in love with that or that model. It's because we are all facing the same challenges, trying to seize the same opportunities, what you said on trust, what you said on surveillance. The question of surveillance is increasingly part of the public debate in many countries around the world. And that's what is interesting. And that's what's interesting in this remarkable judgment of August, which confirms that, and this echoes very much what you just said, that we are dealing here with a universal value, a universal right. It's not true that privacy is a relative concept, is a cultural-based concept, is as I've often heard, especially I must say on the other side of the Atlantic, is a sort of European obsession. No, that's not the case. Privacy, especially in the digital era, is more than ever both a central element of a open, free and democratic society, and that's what the Supreme Court said when stressing that it's an essential facet of the dignity of the human being and an important component of a competitive economy open to innovation, and that includes open to transfers. What is important in the judgment and in the consultation, the report, I must say that this report is remarkable. It asks all the exact questions. I would have liked that we would, before launching our reform, we made a consultation, but it was a much, I would say, slimmer document, and it missed probably some of these questions that then we had to discover through the process. But what is important here is that there's a unique opportunity to build on those shared principles, and I insist on shares that have been recognized, including by the Supreme Court, build on those shared principles and on those shared values to indeed contribute to a worldwide, a global debate. There's an increasing need for international standards in that area, and I think, as Joe said, that there's an opportunity here for India to contribute to the debate and take the lead. And it's of course also a unique opportunity to build on that convergence, to facilitate data flows and ensures the continuity of protection. We had you were so kind to mention the strategy we had. We published a communication 1 year ago, which is titled Exchanging and Protecting Personal Data in a Globalized World, and in which we had identified India as a country with whom we would like to explore ways to facilitate data flows, including adequacy, depending, of course, on the convergence, that could exist between the two systems. And I think it was very relevant that in his remarks at the end of the last India-EU summit, President Juncker, meeting with Prime Minister Modi, made very clear statements on the importance of data flows and on building that convergence, on building on that convergence to facilitate data flow. So I think that we have here a number, really a unique opportunity to advance that agenda, and that's why I also was looking forward to our conversation today. And to also, if there's still time, to answering some questions from the audience.
Thanks a lot. Before really giving the opportunity to the audience for a few questions, I would like to take the opportunity. I see a great role of leadership for the European Commission. I see a lot of leaders around the world, including President Modi, calling for free data flows, keep data flowing globally. But then at the same time, we live in a time of legal uncertainty. The Schrems II case, the standard contractual clauses are questioned. At the same time, there are some trends for data localization, and this is something that India is taking into account. So how can we strike the balance between these two trends?
Well, you've seen that I haven't mentioned even the terrible acronym of GDPR, because I was stressing on what are the common principles. But if you want me to, one moment, step back into the EU type of approach to privacy, I want to stress very clearly, and that's something which is very important for us, our system has never been based on any form of data localization or for storage. We believe in a system that both ensures a high level of protection and is open to transfers. Actually, ensuring a high level of protection is a condition for safe and free and stable transfers. So there's no opposition. On the contrary, there's a complementarity there. You say there's uncertainty. Yes, indeed. International transfers, and I think that's good actually, are no longer only a technical issue. They are part for all the questions we discussed and the issues we tackled today, from trust to surveillance. They are part of they are societal issues that are part of the legal debate, of the political debate, etc. But what is the solution here? I would say that and we all want, and we all want stable basis for transfers, the best answer to that, and I would say the long-lasting answer to that, is building on those common principles I was mentioning. Having laws, having independent supervisory authority, having those set of enforceable individual rights. Those are the elements of a solution that then can pass the high, yes, legal and political test. If I may add a footnote on adequacy, because adequacy is often mentioned. Yes, adequacy is subject to a high test. There's a good reason for that, because adequacy means assimilating a third country to a member state of the Union as far as data transfers are concerned. It means that a transfer between the EU and a third country is assimilated to a transmission of data between Belgium, since we're in Brussels, and France. Although, of course, that third country is not subject to the same rules. It doesn't require a photocopy, so this is not about going around the world and asking a carbon copy of the GDPR. It requires a comparable high level of protection, which can be ensured through different means that was even recognized by the court. But just wanted to clarify that notion, and also, I would say, the way we are approaching that notion.
Thanks a lot, Bruno. I saw a gentleman in the audience that would like to raise a question. Thank you.
Hi, Pat Walsh, Privacy Matters. It's a question for the panel in relation both to the Supreme Court decision and a proposal for a data protection law. And it comes back to the discussion of a mobile-first strategy for India. It comes back to then, for me, data localization. In fact, India does have a data localization law. The telecom license conditions prohibit telecom operators from sending subscriber and account information to a third country. That's a fact, and that's a major challenge. And then secondly, what is the panel's view on the requirement for people to register their identity, including the biometric registration, including the biometric data, to obtain a mobile SIM card? And in Jammu and Kashmir, for example, you have to have police approval before you can have a mobile phone SIM card. And then in addition to having to register all of those details, you also have to register your Aadhaar number to obtain a mobile phone card, to obtain a SIM card. So actually, Mal, when it comes to these discussions of fundamental rights, and I agree with everything you've said, by the way, these are fundamental challenges in India. So what does the panel think then? How will the Supreme Court decision and the proposal for a data protection law impact in a mobile-first strategy?
Probably Rama can take the first question. Thank you.
Thank you, Riccardo. One disclaimer, I don't represent government, so I'm giving a viewpoint to address the question. One thing that the committee is definitely looking to is, which I did not state in the previous intervention from my end, is that committee, whatever recommendations it makes to the government, has to ensure that we are conforming in principle and in spirit to the Supreme Court judgment. So while that is not directly our charter, we will ensure that the report that we submit to government, in principle and in spirit, it conforms to the Supreme Court judgment. And on the second question that he has raised, yeah, we have a mobile-first strategy. Currently, India has gone down a certain path in terms of using technology for driving inclusion at a faster pace, whether it is in opening bank accounts, enabling e-KYC for mobile services expansion or for digital payments expansion. But all of this will get revisited because very clearly when the data protection law is drafted, the committee is also going to make recommendations on potential changes that have to be made to the IT Act, to the Aadhaar Act, to the Consumer Grievances, the Consumer Protection Bill, maybe the telecom regulatory, whatever guidelines that are there. So all of this would get revisited in terms of asking for the biometric information. E-KYC was an enabler that the government and the state governments have thought so that the direct benefits can be credited, accounts can be opened at a faster pace, but that is getting debated in the Supreme Court, so we'll have to wait for that. But as far as this committee goes, it will not only look at trying to enshrine the principles that come out of the Supreme Court judgment and in spirit, protecting the privacy rights of the citizens, that we will be looking at aligning our recommendations with that, and also looking at making recommendations on what potentially amendments that need to be made in all allied laws which might impact on this. So we will be looking at this. Yeah, the gentleman who asked the question has a valid point. I think the certain path that we have gone on in terms of e-KYC and biometrics captured by so many allied agencies which are either authenticating data or collecting data for enrollment. I think some of these need to get revisited as the data protection legislation gets
Malavika,
I'll just add very briefly, given we don't have much time, that this was the judgment only on the privacy angle. This was a referral to the Constitution bench of the Supreme Court on the Attorney General's claim that Indians don't have a right to privacy, therefore a claim under all of the arguments against the biometric ID scheme didn't stand, because if there is no right to privacy, where's the question of violating this non-existent right? So this was sort of a little detour along the trajectory of challenging the constitutionality of the ID program. And that set of judgments, that set of hearings is ongoing right now. It's going to go on for the next few weeks. So we're going to see what happens then. So the fact that the privacy matter was settled along the way is really useful, and it will help inform how Aadhaar is looked at. But I think one of the problems we're dealing with, and this is something I sort of prophesied like a Cassandra many years ago, was that by delaying those cases coming up before the court, you've now got to a point where it's reached the too big to fail state, where like but we've almost enrolled every single person in the country. How could we now dismantle this? So that's exactly what I had feared would happen, and that is what is happening. But I think watch this space around how the ID scheme is dealt with, because I think that's a whole other panel than this one. And Pat, I'm happy to catch up with you separately.
Thank you very much. If there are no other questions, we have been kindly reminded that the session is over. So if there are no further comments from Delhi, I would like to and if there are no other questions here in the room or in Delhi, I don't know if we have time.
We do have one comment here in Delhi.
Oh, thank you, David.
So my question is actually to Rama. So Rama, you mentioned about that the committee is not actually going to draft a law. Now, when I look at the terms of recommendation on the 31st July, it actually says that a draft bill should be prepared by the committee. Of course, ultimately, legislature has to make the law finally, but just like the Financial Services and Legislative Reforms Commission, which was also, by the way, was chaired by the same assistant plan. So they had come out with a report as well as the draft legislation. I just wanted the clarity on that aspect, only in terms of a draft legislation. Thank you.
Currently, the focus is there is a draft white paper that came out. This is based on what the Justice himself shared in the public consultation. We need to take all the feedback, including the written submissions and the public consultations, and make that final report submission. I think that is the immediate target. It's possible that the committee might help in the draft law, but currently the focus of the committee is to, I'm sure that the legal team will also validate that.
And we've got one last comment, and then I know we're over time.
Really over time, David.
Open up here after we break the video in for further conversation here in Delhi.
So, as you say, not to the discussions that we're having immediately, but on the point of view, the idea of having a heavy handed regulation and how does it impact business? So, if it reflects on when GDPR was enacted and now it's getting enforced in May 2018. So, what is the profession and what is the kind of business that is getting immediate traction because of this heavy-handed regulation? It is a legal and a compliance business, not the individuals and the businesses and the companies who design solutions for improving security and privacy, not the companies like Big Four and consulting companies who actually help organizations have a secure and privacy-aware framework to protect data. So we also have to ensure that whatever we make, I'm not against the legal framework getting traction in like a lot of business, because I also like aspire to be a lawyer someday. But the point is we have to make laws that do not increase the cost of compliance, because that is passed on to the consumers in some form. Riccardo, I think that's it here for Delhi.
Thanks a lot. Thanks a lot, David. Thanks a lot, everybody in Delhi. I think that Bruno Gencarelli wants to have a final comment from here, and then we can wrap up.
Yes, because if this was a characterization of what we did in Europe, it's a wrong characterization. I have no time to explain why, indeed, is, but with the GDPR, we significantly cut compliance costs by not only harmonizing the laws in Europe, by simplifying data protection rules, by introducing an approach, for instance, based on the risks, where moving away from a one-size-fits-it-all approach, we have now an approach where obligations are graduated according to, on the basis of the level of risks that processing operation involve, which means that certain processing operations which are for more mundane or day-to-day nature are not subject to a certain number of obligations. We introduced, and that was already discussed, the notion of privacy by default and privacy by design, which are drivers for innovation and for using privacy as a competitive advantage. So these descriptions of over prescriptiveness of European laws or other laws are simply inaccurate.
Okay, I want anyway to conclude with a very positive note. I think today we created a good privacy bridge between India and Europe today. So I think this is a good foundation for further dialogue and to understand and try to somehow come closer with viable solutions. Please join me in a big round of applause for our speakers here in Brussels and in Delhi.